Hello everyone, we come back to informed consent. That's a problem that it's still important for medicine, for not only in euthanasia but also in involuntary admission in the psychiatric hospital. The central ethical problem of our presentation is the valid consent from the perspective of theory of international human rights law, because we will present a case, Atudorei versus Romania. It's a case that was judged in the European Court of Human Rights. But first, in the context of literature, the concept of valid consent is accredited instead of informed consent. Sometimes informed consent is changed with valid consent for legal perspectives, because in the case of involuntary admission, for instance, the full informed consent maybe cannot be provided, but a valid consent should be provided. So the case study that we start is Atudorei versus Romania. That was a case that was presented at the European Court of Human Rights and was referred of the case of involuntary psychiatric hospitalization. More specifically, it was a person that was institutionalized by her family with accord with the doctors, in the context that she was practicing, she was an adept of a new religious movement, one movement that was involved yoga practice. It was considered a sect in Romania at 2004. So this was the motive that they try to intake the patient, and the parents wants to remove this person from the influence of this yoga movement, from this spiritual movement. She was not agree, but in that period in Romania there was a big scandal with this yoga movement. Was notorious that this movement have brainwashed their adults, and they were considered that this person cannot have a valid consent, because her autonomy was limited by the practicing of this sects, or the practice of this Asian, Indian type of yoga, and they say she was under influence, under maleficent influence of a guru, so she cannot have a valid consent. So they called into questions the basic reason for hospitalization, is the plain if really developed the mental disorder, because she was she testified in front of the court that she was followed by very strictly by her family, starting from her childhood, not only after she was practicing yoga, but also before. She was somehow linked with her family. She was very constrict, and the parents have an abusive behavior, and there was a problem. The court testified that we cannot know if the practicing of yoga could put her in the situation of not have a real judgment, a real balancing judgment, so cannot consent. But if the childhood make her her presence, and she wants to escape from her families and from her influence. So the moment when she was institutionalized was when she wants to marry with her fiancé that was part of the same spiritual movement, and for preventing this marriage, the family decides to institutionalize, and the Human Rights Court considered that she still have, even she has a diminished capacity, because in this anti-sect movement, they say often that the capacity to consent is diminished, and the gurus or the leader of the cult have a maleficent influence on that person. But in this situation, the European Court says, okay, but she still has a right to have civil rights to marriage or to practice religion, even have a diminished capacity, but this diminished capacity was never proved or attested by medical test, by psychiatric evaluation, or at least by 2 psychiatric evaluations. There was only 1 psychiatric evaluation. The one was made in internment, but not confirmed by another psychiatrist after that. So, from our bioethical point of view, informed consent can be valid even if it's not complete, and that is the patient did not have access to all available information, but only to those the doctor considered the patient competent to understand. The consent is valid if it is fully informed, but not only if it is fully informed, but if it was communicate the problem, and in the language that the patient understand, or in the language that can understand, and if she was taken out for a limited period from this spiritual movement and take out from influence of this sect, she can consent. Of course, the valid consent can be altered by the psychical state in the case of a treatment, or in the case of actual disease that is invalidating for mental capacity. But this should not limit her capacity to overtake the decision about her state of health, and also her state of freedom, or voluntary or involuntary admission in the hospitals. So when a person that have, for instance, a stroke when a person has a stroke, one member of the family should also consent about the treatment or about withdrawal of the treatment. So there is a situation when this voluntary consent or could be limited, but this limitation should be made in such way that the basic human right should not be altered. There are a number of elements that make informed consent invalid: coercion, fraud or manipulation, as long as the moral norm is only idealized, not having the constraint force of the legal norm. In its application represents a pure virtue. So this norm of informed consent should be transformed from a simple bioethical norm to the legal, to enforce by the legal practice, by the legal representation. Ethics based on justice and equity, because it's benefit from normative transposition codified by law, has a punitive force, and as such represent a behavior adopted and imposed as society level. So thank you very much. This was my presentation.
Thank you. We have time for some questions, comments. No questions. I think the topic of informed consent is always controversial, and there are many factors playing the background of informed consent, and agriculture, right, as well, concept of